Good evening, everyone, and welcome to the certificate course on insolvency and bankruptcy laws. Today, we'll be continuing our discussion on the topic of evolution of insolvency and bankruptcy laws in India. And for the same, today we'll be going to take a look at the report submitted by the Bankruptcy Laws Reforms Committee in the year 2015, through which the present Insolvency and Bankruptcy Code 2016 came into being. So this committee was constituted on 22nd August 2014, and it was chaired by Dr. T.K. Vishwanathan. And this report has submitted its final version on 4th of November 2015, which is divided into two volumes. In the first volume, the committee has recorded its findings and recommended what all should be there in a consolidated insolvency and bankruptcy code. And secondly, the committee has also attached in volume 2 a draft insolvency and bankruptcy code. So why this committee report is necessary is because this committee report helps us understand the very core of the insolvency and bankruptcy code. What are the goals, what are the objectives, and uh, how this insolvency and bankruptcy code is indeed a futuristic code. So therefore, the study of this report becomes necessary. And when we move forward towards part one, which is titled as acknowledgements, we find two very interesting paras written by this committee. The first para, in this first para, the committee highlights the dynamic business system of India. And it also notes that the young entrepreneurs are usually crippled by the present environment because there is the current insolvency and bankruptcy framework is having long delays, and they usually end up bearing high costs, and which is why ultimately their businesses tend to fail. And in the second para, this committee report highlights that India is having some of the lowest credit compared to the size of the economy of India. And the committee highlights that this is a call for change because the availability of the credit in the market is must for especially for the young entrepreneurs who are now coming up with all the latest ideas, all the innovative ideas, but are short of funds to run a business. Therefore, the ultimate ambition of this committee was to address the problems of the previous insolvency and bankruptcy framework and to propose a code which will be beneficial to all the young entrepreneurs and to create a market where the resolution of an insolvent or a bankrupt entity is swift and efficacious. So, moving forward, in part two of this committee report, which is titled as Executive Summary, this committee has summarized all its findings and all its recommendation in this part two. And if we are to understand this report in a quick manner, part two is very essential. But for the present session, we will be directly starting with part three of this report because in part three, the committee addresses the first very important question, that is why reforms. And as also we have had a discussion on this yesterday in the previous session, that the credit markets due to the earlier bankruptcy laws were malfunctioning for one reason or the other. And this committee also specifically notes that what they are doing now is to bring in a comprehensive reform and not any incremental change, meaning thereby that this, which we have seen in the previous laws from SICA to RDB Act and from RDB Act to SURFACI Act, those legislation though progressed in a manner, but they focused on very small changes. For example, from RDB Act to SURFACI Act, we can see there is a shift in the model that is from debtor in possession model to creditor in possession model. Therefore, this committee has proposed that all those laws fall short at some place or the other, which is why the present need is to have a comprehensive code in which all the entities are covered, all the creditors are covered, and all the solutions can be um addressed under one single umbrella, which is the IBC. Then, this committee has also highlighted some very basic economic principles of bankruptcy and what a bankruptcy, when an entity goes bankrupt, what does it require? So, firstly, when we talk about when an entity goes insolvent, the first and foremost question is that what should be done? Whether this entity should be reorganized, its assets and liabilities should be reorganized in such a fashion that the business of the entity may revive, or if there is no possibility of such revival, should the entity be directly liquidated? So, therefore, financial rearrangement becomes one of the most important principles while dealing with an insolvent or a bankrupt entity. Secondly, viability assessment. What is viability assessment? Viability assessment is somewhat similar to assess is basically when we assess in advance that whether or not this entity will be bankrupt or insolvent in future. So that viability assessment should be done before the entity is actually declared insolvent or bankrupt. Also, this committee has discussed the problems which was there in the current framework in India, which we had already discussed in the previous session. That is the fragmented legal framework with the SURFACE legislation, SICA Act, and how the multiple forums were, um, uh, because of there being multiple forums, there were many delays in the proceedings, and ultimately the outcome was very poor. So this new bankruptcy code focuses on certainty, that is a one single process for resolving insolvency, which will promote the efficiency and overall growth of business in the market. The idea is not to save the persons behind a company or a partnership firm, or let's say to safeguard a sole proprietor, but the idea is to save the business, and which will ultimately contribute to the overall economic growth. Secondly, the maximization of value of assets. That this particular code should be offering such a swift process that the asset value of the bankrupt or insolvent entities should be maximized in such a manner that most of the creditors should get the actual value which they have lent to the debtor. Thirdly, this code also proposes a treatment which shall be fair to all the participants, all the stakeholders. There should be an equitable treatment, meaning which when an insolvency process is started, all the creditors should be able to file their claim in a single place, and all the creditors should be paid off in a proportionate manner and also in a priority manner. For example, if a secured creditor is there and if there is also an unsecured creditor, so the secured creditor must be paid in priority to the unsecured creditor, because for a secured creditor, the stakes are higher, the risk is higher. Then we talk about transparency. And this proceedings, the insolvency proceedings, which this code has created, is focused on transparency also because it involves the participation of all the stakeholders. So there may not be any conflicts between the among the stakeholders, and there will be no different proceedings, and all the stakeholders' interests will be looked upon in the same proceedings, and which will ultimately benefit the stakeholders in taking a well thought decision to revive the business. Now, this committee has also identified the features of the a good insolvency and bankruptcy law. And number one being a unified code. As we have already discussed, that all the entities, be it company, partnership firm, individuals, limited liability partnership, all these entities should have a single code, a single way out to the insolvency or bankruptcy situation. Secondly, this committee has also noted that in the earlier legislations, there was no systematic flow of information, which also resulted in the multiplicity of the proceedings. So, this committee has focused on making a system where the information regarding a creditor or the debtor should be available at one place so that all the creditors and the debtor and other participants may be sufficiently informed for a good decision making. Then, thirdly, this committee has proposed a calm period, which is also technically known as moratorium period, which is once a uh, company or once a debtor is declared insolvent, then all the other options of debt recovery should be halted so that there will be no competition among the stakeholders themselves. And they should all come at a one place and negotiate between them and ultimately work for the revival of the business of that particular entity. And also, this committee has proposed that there should be an insolvency professional. Now, in the earlier legislation, as we have seen, when a company is ordered to be wound up or liquidated, the court usually used to appoint an official liquidator who will take control of the assets and management of the debtor. Now, under this code, this committee has proposed to create a separate post known as insolvency professionals or resolution professionals. Now, these professionals are tasked with the uh, overall management of the resolution and liquidation process. From the very date when the insolvency resolution proceedings are initiated, this resolution professional will come forward and take over the control and assets of the debtor. And this resolution professional will supervise the resolution proceedings. In what manner? The resolution professional is tasked with organizing a committee of creditors where all the creditors will meet and will be filing their claims and will be taking a decision on whether to revive this particular entity or to liquidate this entity. Having such a unified bankruptcy code will have the have will have multiple benefits. One of the benefits is that there will be reduction in the emphasis on secure credit, which means in the pre-IBC era, the banks or the financial institutions were majorly focused on lending to asset-heavy industries, and most of the labor-intensive industries did not used to get that much of loans. For example, if a country is having assets worth rupees 100 crore, then the banks would be more interested in lending loans to such an institution because they can get a collateral worth rupees 100 crore. But on the other hand, if there is a software company who is having only a single or two offices, they will not be in a position to get a secure loan from the banks because the banks are adverse to lend to such industries because of the insolvency and bankruptcy framework in force at those times. So this committee is focused on creating an environment where the banks and financial institutions and other creditors are more focused on to take a bet on the business prospect of a company, that how this company is having an innovative ideas for growth of the business, and they should bet on such ideas rather than the assets of an institution. So the overall idea is to promote the entrepreneurship in the market and not just debt recovery. Now, having discussed the objectives of this committee and what all the benefits this committee is foreseeing with the implementation of this insolvency and bankruptcy code, how this committee ensures that these objectives and these benefits be actually materialized when once this insolvency and bankruptcy code come into force. So for that, this committee in its part 4 of the report discussed the institutional infrastructure it seeks to establish. And this part 4 is very interesting because we can see a lot of new ideas here, a lot of new steps which were being taken by the committee, and which was then, after the recommendations of the committee, was actually taken. And in totally new infrastructure for the first time in India was established. So firstly, this committee suggested to establish an independent regulator, which is now the Insolvency and Bankruptcy Board of India, the IBBI, and how this IBBI was recommended by this committee. We'll take a look at that now. So, the committee has made a case that there should be an independent regulator. Why? Because this independent regulator will be having a legislative branch, an executive branch, and also an quasi-judicial branch. Now, uh, how this committee explains that why this regulator is necessary. So, this committee has taken into observation that in the insolvency and bankruptcy framework, uh, there is a requirement at each step to encode the very detailed procedures. And this insolvency and bankruptcy field is ever changing because the market situations are changing, the market trends are coming forward, so the lending practices of the banks change. So, in response to that, the insolvency and bankruptcy code should also be able to adapt those changes. And for that purpose, this regulator is necessary, and it is necessary to give this regulator the legislative power. So this committee has proposed to create IBC containing the major ultimate principles and to task this regulator to make further regulations to address the intricacies in response to the changing conditions. So, so that a detailed law can be made at each point of time, and uh, this and it is not always necessary to knock the doors of the parliament for each and every question which may come up for consideration in these proceedings. Therefore, this regulator was necessary, and it was recommended by the committee that it may be created as a statutory body such as SEBI and RBI, so that this regulator can work independently and also effectively. Along with this regulator, along with IBBI, this committee has also proposed to create two regulated industries, one of information utilities and the other of insolvency professional and agencies. Now, moving forward, that what all this committee seeks to have for IBBI, one of the thing this committee proposed that there should be a statistical system which should be maintained by the IBBI, that is the data regarding the insolvency and bankruptcy process of an organization should be maintained by the IBBI on day-to-day basis, and this data should be readily available for the public so that there will be transparency and there will be a systematic flow of information. Now, this committee has laid down the what should be the functions of this regulator, and it has also categorized some statistical and research functions, which we have already discussed, that primarily the IBBI was tasked with to create regulations, and it should have legislative, executive, and quasi-judicial functions with respect to the two regulated industries, which is the information utility and insolvency professionals. And legislative functions with regard to these industries means that the IBBI is tasked to create regulations for the effective working of the information utilities as well as the insolvency professionals. Executive function is that the IBI will have the power to inspect at any time the records of such information utility and the insolvency professionals, and quasi-judicial functions involve the taking up of the administrative proceeding. Usually, if you visit the website of IBBI, you can find there will be a separate column wherein the IBBI has published disciplinary proceedings taken against the insolvency professionals. So those taking up of disciplinary proceedings against insolvency professionals is one of the example of the quasi-judicial functions of the IBBI. And thirdly, we have already discussed that to create such a system of information that it is easy for the public to get hold of the data regarding a organization and be easily available whenever an insolvency or bankruptcy proceeding is initiated, to file their claims and to approach the appropriate authority. Then, moving forward, we'll now take a look at yes, this is one very important point. How should this IBBI to be set up? Should it be set up as a statutory body? Should it be granted financial and operational independence, or should there be any arm of government involved in the management of this board? So what this committee has proposed that to be free from all the corrupt practices, this IBBI should be set up as an independent statutory body, and it should have its separate rules, code of ethics, and it should create a separate framework for its working so as to be free from all the political interferences. The powers of the IBBI and the functions of the IBBI are laid down in section 189 and 190 of the IBC, which you can refer, and you will get an idea how the IBC gives a financial autonomy, a working autonomy to the IBBI. Now, these you will find these green colored boxes in the BLRC report. So what this BLRC has done? BLRC has given a model points for the IBBI to create rules and regulations. So for example, um, these are drafting instructions for rules on performance reporting by the board. So here the committee has proposed that a set of rules should be framed on these points so that this board can be held accountable for its work. For example, in point number 1, it is written the board should create 2 annual reports, one audited report which is comparable to the traditional financing reporting, and performance report which incorporates global best practices system of measuring the efficiency of regulatory system. So this committee has proposed that this board should be accountable for all the work which it is undertaking, and it should on yearly basis create reports and submit it to the central government so as to evaluate its performance on year basis and to identify the problems and in what manner those problems should be resolved and the working can be improved. So these green boxes in the report reflects the drafting instructions given by the committee, and on these points, you will find a lot many regulations which have been made by the IBBI and rules made by the central government. Now, now this committee do says that the IBBI should have legislative functions, but how this legislative functions should be carried out. So when we talk about regulation making, and when this committee has said that there should be the ultimate principles should be incorporated in the IBCs, and the detailed question of procedures should be addressed through the making of regulations by the IBPI. So this committee proposed that while addressing such issues, such detailed question of procedures, the IBBI should always take into consideration the public comments. And therefore, if you go on the IBBI website, you will find a separate column for public comments. So before the IBBI propose some amendments in the regulations, they always release a discussion paper and invite public comments so that the legal professionals, insolvency professionals, industry stakeholders, and other academicians and professors may submit their comments for the better enactment of the regulations. Furthermore, when there is a regulator like IBBI and it is supervising two regulated industries, which we have discussed to be the insolvency professionals and information utilities, this committee has proposed that this regulator must release guidelines for such IPs and IUs for their better functioning. And if those guidelines are violated, the regulator must not be given any power to penalize them. Rather, the reason for violation should be looked into and should be addressed for the better functioning of the overall system. Now, as we have already discussed, what will be the executive function? It will include inspections, investigations, and enforcement of orders, processing of complaints. And we have already discussed the quasi-judicial function of the IBBI, that if there is any disciplinary proceeding is to be carried out against an insolvency professional, so they can file a complaint with the IBBI, and IBBI will take up the administrative proceedings and they will pass a clear order, which is also appealable to the National Company Law Appellate Tribunal. So the IBBI alone is not empowered to take decisions as freely it wants. It is also, the committee has also proposed to keep IBBI under control as well. So here we can see that committee recommends NCLAT to be the appellate forum for the appeal against the board's order, with a further statutory right to approach the Supreme Court. Then we move forward and we'll have a look at the bankruptcy and the insolvency judicator. Now, when we talk about having an insolvency professional, who is this insolvency professional and what all tasks this insolvency professional should take up? Now, these insolvency professionals, just a minute, we'll first have a look at the insolvency professional and then we'll come to the adjudicator, who is the NCLT. Information utilities. I'll directly go to insolvency professional first for easy understanding. Yes. So this committee has proposed that once an insolvency proceedings is initiated, a separate officer should be appointed to look after the entire insolvency and bankruptcy process. Now, why this separate independent officer is necessary? This officer is necessary to minimize the role of the debtor, that is the promoters of an insolvent entity, and to minimize the corrupt practices, to minimize the siphoning of the assets of debtor. So this insolvency professional come into picture. He takes control over the assets and management of the debtor, and this insolvency professional releases a public announcement, invite all the creditors to file their claims to be a part of a committee of creditors so that effective meetings can be carried out and decisions can be taken to whether they revive this particular entity or to send it into a liquidation. This insolvency professional is also tasked with inviting the prospective resolution applicants. Resolution applicants, in simple words, is a person who files a detailed plan to revive a company. So basically, a separate person comes forward and takes over the assets and liabilities of a company, and it proposes in his plan that what all amount of money he is willing to pay off the debts of the company. So that task, inviting the resolution plans and putting them forward before the committee of creditors, all these tasks are given to this insolvency professional. And that is why the role of insolvency professional becomes very significant while carrying out the insolvency proceedings. But this insolvency professional is not awarded with so much of independence, because the committee has observed that these resolution professional can also be swayed away by the creditors to benefit one or the other creditor. So above these insolvency professionals, this committee has proposed to establish an adjudicating authority, which is the NCLT in the case of Insolvency and Bankruptcy Code, when it is applicable to the companies. Now we'll take a look at the adjudicators and what this committee has proposed. So the bankruptcy and insolvency adjudicator. Now, this committee has discussed that there are two different phases under the code. First is the insolvency resolution process, and the last resort being the liquidation process and the appointment of insolvency professional. And above that, this committee has proposed to establish an adjudicator who will supervise the overall proceedings of the overall resolution proceedings, and also to supervise the liquidation process carried out by this insolvency professional. Now, this committee has proposed to segregate the adjudicating authorities for companies and for individuals and partnership firms. Now, why is that? Now, when we talk about insolvent firm insolvency or firm liquidation, we have seen that this committee has also observed that under the Companies Act 2013 as well as the Limited Liability Partnership Act 2008, whenever there is a winding up proceeding or liquidation proceeding, matters being handled by the NCLT, and NCLAT being the appellate authority to the NCLT. So this committee recommends that the under the IBC, the process should be the same. The NCLT should be tasked with the applications for the insolvency resolution proceedings of the company, and also for the liquidation purposes also. But when it comes to the individual insolvency and bankruptcy, so earlier on individual insolvency and bankruptcy, there were two major acts: Presidency Towns Insolvency Act of 1909 and Provincial Insolvency Act of 1920. Now these acts were pre-British era act, pre-independence era acts, and these acts are still in force because Part 3 of the IBC has not been yet notified with respect to the individuals and partnership firms. So this committee discussed that the primary goal for insolvency resolution proceedings for of a company and of an individual are similar, but the institutional framework which will be the requirement in an individual insolvency will be much more. And currently, in the year 2015, there were not much NCLTs. However, in comparison to if we see the individual bankruptcy regime, then we need to have an adjudicator at in every state, in every district. Therefore, this committee recommends that DRTs, debt recovery tribunals, to be the appropriate adjudicating authority when it comes to the individual insolvency, because uh, in the year 2015, as well as even almost after 8 years, the DRTs are having much more presence in the country as compared to NCLTs. That is why this committee proposed that DRTs should be the appropriate adjudicator in the case of individual insolvency. And then, as we have already discussed, the administrative law wing of the IBBI, an appropriate forum for that to be the National Company Law Appellate Tribunal. Now, how to determine the territorial jurisdiction of these adjudicators? So, under the Companies Act, this committee has noted that it is either the location of a registered office of a company or for a debtor, or under the SURFACI or RDB Act, there was the territorial jurisdiction was determined by the location of the bank branch. Then, what should be the territorial jurisdiction under the present IBC? So, this committee has recommended that location of the registered office of the debtor should be the jurisdiction of the NCLT, or the DRT. So, and this committee has also specifically included a provision which is that jurisdiction of any civil court is to be barred when it comes to the claim of the creditors pertaining to the insolvency and liquidation of an entity. And all the claims are to be presented before NCLT, DRT only, so that the insolvency resolution process as well as the liquidation process be streamlined and there may not be any conflict of interest between the stakeholders themselves. Now, here the committee has given some drafting instruction on the jurisdiction of the tribunal, and these instructions, as I have written, they are materialized in shape of these sections. So you may have a look at it. Then, when we talk about the procedural rules, the central government is the appropriate authority to prescribe rules for the efficient working of these adjudicators. And then the regulations are tasked with the IBBI, as we have already discussed. So, how to, once these adjudicators are established, how to increase the efficiency in their working? So this committee has taken a futuristic approach here, and it has also recommended that these adjudicators, these tribunals, should work on a totally computerized system. E-filing software should be there in a web-based format where the drafting and filing and online payment provision should be included. And these websites should have a continuous updating so as to meet the changes which may be there. And however, this committee has also recommended that there should be a limit on the page numbers. So this committee has gone into very much intricacies to recommend how the working of these tribunals can become effective and efficient. So this committee has recommended that there should be a page limit, there should be a 24/7 filing system, and the submission format, this committee has highlighted a text searchable PDF, so as to whenever an adjudicating authority is perusing the file, they can easily use the system, they can easily go Control+F and they can search whatever the relevant part they want to go. So that is how this committee has recommended that this is how the case filing systems are to be established for the smooth functioning of this committee. And they have also recommended that the judges who are being appointed in these adjudicating authorities, they should get a separate research team to brief them as to how the systems are working, the video conferencing system, the e-filing system, so that the judges are also equipped with the technical assistance and they can also work better. Then, yes, all these points are there. Then yes, also this committee has also recommended that how the budgeting of these tribunals should take place. So these tribunals are These tribunals are required to submit a yearly progress report or performance report and also yearly financial statements so that the IBBI or the central government can take into consideration that how these tribunals are functioning and how much funding is required for each tribunal so that the corrupt practices may be curbed and the appropriate funding should be provided for the working of these tribunals. Now, when we talk about establishing a swift case filing management system, this committee has noted few points. For example, when a person is approaching a court, what all he needs to establish for the purpose of an insolvency proceedings. Number one, that I have lended money to so and so creditor. Number two, that that lended money became due on so and so date. That from that date, that debtor was liable to pay me. And number three, that a particular debtor has defaulted in making the repayment of the loan. So as these three aspects are very much important, this committee has recommended that the documentary process in the filing system should be streamlined in such a manner that the claimant is required to submit that on basis of what contract he has lent the money and on what basis on which date the money became due and on which date the debtor defaulted in repaying, so that the uh, adjudicating authority, while adjudicating the application filed by a creditor, their decision making can be swift. Further, this committee has proposed that there should be an establishment of an information utility for the better functioning of these adjudicating authorities. And it has also referred to the Aadhaar system, which is very much prevalent in our country. We can see that now there is a linking of Aadhaar and PAN, and there is a very swift system whenever with respect to the individual's information. For example, if we see at the airports, DG Yatra app is now there, which links the Aadhaar to our boarding pass, and you can just scan your code and directly enter the airport. So this committee is also proposing to create such kind of a system so that the traditional ways, the traditional delays which are there, they can be cut out and the faster decision making can be there. And for the same, this committee has proposed to create a competitive industry of the information utilities. Now, what are these information utilities? And how this committee recommends that these information utilities will be beneficial for the effective working of the adjudicating authorities. So, when we come to the information utilities, the committee has recommended that the Insolvency and Bankruptcy Board of India should create a competitive market for information utilities. These particular information utilities can be a private limited company or public limited company, and their main task is to maintain a system where all the information with regards to the uh, money lending by the banks to a company and on a basis of the contract, on the basis of which the money is being lent, the security interest attached to that contract, what is the date for repayment, and if whether or not that particular debtor is paying the timely interest. All such information should be stored in one place so that whenever a claim is filed before the adjudicating authority, he can just knock on the door of the information utility and get the appropriate verified record for a better decision making. And that is why this committee has recommended the creation of information utilities. Now, this committee has also proposed that there should not be a single information utilities, and it has foreseen that there should be a open market for the players to enter and take up the role of information utilities in each state of the country. Because of the diversification in the business, the presence of banks in shape of different branches in different states. So there is a lot of information, and a single information utility cannot possibly maintain a centralized information database. Therefore, they, this committee has proposed this information utility to be a spread out industry throughout the nation. And they have also recommended that this information may be available to general public at a very reasonable cost, and such a cost should not vary from one information utility to other information utility, and there should be one charge for the release of information. Now, we have discussed this, that what all information should a information utility have, the liabilities of an insolvent of a solvent entity, clear evidence of the instance of default, record of assets pledged as collateral against secured credit, balance sheet and cash flow statements of the entity. All these things are to be filed with the information utility so that the adjudicating authority can get this information, or for that matter, the creditor can get all these informations in just one go, and a faster decision making can be there. Now, moving forward, this is about the information utilities. Then we first discuss the triggering of the insolvency resolution process, and then we'll have a discussion on the role of the information utility in the case of operational creditors. So we move forward to the triggering of the IRP and how this committee has proposed that the insolvency resolution process be taken up. Yes. So how can the insolvency resolution process, or the IRP, be triggered? So what this committee has uh, done in its report, or has recommended in its report, is the categorization of creditors into two categories. We have also had a very short discussion on this in the previous session, and we have also seen that the applicability of the previous acts was to a very limited set of creditors. So this committee has sought to include each and every creditor in the as a part of insolvency resolution process, and for that purpose, this committee has recommended to divide the creditors into two categories. One is financial creditors, and second is operational creditors. So to discuss in very brief, financial creditors are those creditors whose relationship with the debtor is purely financial. So, for example, banks, financial institutions, they lend money and they get back the interest and the repayment. So it is a purely financial setup, and or their act of lending the money, it is basically a financial relationship between the two parties uh, under the category of financial creditors. And second category which this committee has created is the category of operational creditors, which include the creditors. Whenever an entity is buying or buying materials, goods, and or are availing services from different persons on credit basis. So those creditors come under the category of operational creditors, and these this category of operational creditors also includes the claims of workmen and employees. So this committee has recommended the categorization of the creditors into these two categories, and it has aimed to cover each and every stakeholder of a company so that they can be a part of insolvency resolution process. Now, when it comes to the triggering of the insolvency resolution process. Now, there is a concept known as balance sheet test. Now, this balance sheet test is basically the evaluation of a balance sheet. When you're comparing the balance sheet, you're comparing the assets and liabilities of a company. So you can easily forecast whether this business is running smoothly, and because we can easily assess the profit and loss of a business, and you can also predict in advance that whether this business is going to survive or it is going to become an insolvent. But this committee has somewhat shown his disagreement with the balance sheet test when it comes to India because of the accounting standards. So this committee has noted that the accounting standards which are being followed in India are not so uh, smooth or not so strict in their implementation, which is why the balance sheet test becomes vulnerable for the Indian insolvency and bankruptcy regime. That is why this committee has proposed a simple triggering method for the insolvency resolution process, which is they have set up a monetary limit. So earlier the limit used to be 10 lakhs, and after the COVID period, there was a notification from central government, and that 10 lakhs limit was increased up to 1 crore. So whenever there has been a default which is more than 1 crore, then only a creditor can come forward before the NCLT and file a claim to declare that particular entity as insolvent and to initiate the insolvency resolution proceedings. Now, what are the requirements for a financial creditor, for an operational creditor, for the initiation of the insolvency resolution process? This will be better understood by you when you will be going through section 7, 8, 9 of the IBC. But just to give you an idea, and what this committee has also recommended, this committee has recommended that a financial creditor should submit the proof of debt, due, and default. And for this purpose, this committee has recommended that it should be mandatory for the financial creditor to get the record from the information utility and put the same before the adjudicating authority, so that the adjudicating authority, as we have already discussed, can easily verify that record and take a faster decision. For operational creditors, the system of filing the application is somewhat different, even under the what is being followed in the IBC, and what is also has been already recommended by the BLRC is that the operational creditor is required to produce an undisputed bill. So, for initiation of an insolvency resolution proceedings by an operational creditor, this is a two-step process. Firstly, the operational creditor is required to serve a notice to the uh, debtor, and then if the debtor does not dispute that bill or does not dispute that notice, then the operational creditor can come forward before the NCLT and show the NCLT that I have already approached the debtor for the repayment, but as he has not made any payment, the IRP be initiated against him. In the other case, the debtor does dispute that notice or the bill which has been affixed with the notice, then the operational creditor and the debtor can firstly settle on that dispute, and later on the decision on insolvency will be taken. Now, as we have discussed that who are the operational creditors in an entity, I take you a bit back to the point where we were discussing about the information utilities, and how this committee has recommended that information utility should maintain record regarding the operational creditors. See, we have to understand that when it comes to a financial creditor, in most of the cases, these financial creditors are banks, financial institutions, and other uh, category of lenders who maintains a very systematic, who has their own ways to maintain a systematic record of the information, because they enter into formal contracts. So it is easy for them to approach the NCLT and file a claim on the basis of that contract. And it is easy for them to file such contracts before the information utility for the record purposes. But when we talk about operational creditors, the market becomes very wide because it will involve each and every from small to medium to large trader. So a small trader who is practicing in a very remote area may not be having a very efficient system of maintaining the record, but still his stakes might be higher in a company who has gone insolvent. So this committee has recommended that the information utility should also maintain a record database for the claims to streamline the claims of operational creditors as well. And for this purpose, this committee has considered an approach which is being currently followed in United Kingdom. And we have also somewhat on this approach has incorporated section 8 and 9 in the IBC for the operational creditors. So in UK, there is something known as statutory demand, which serve as a direct evidence to initiate the insolvency proceedings in that jurisdiction. So basically, in UK, like we have already discussed that operational creditor is required to submit a to serve a demand notice upon the debtor. So in the UK, that process is a bit more formal because the operational creditors do serve a notice upon the debtor, but that notice is not just an formal notice issued by the operational creditor, but a statutory notice. It is being verified by uh, sub, uh, the insolvency service of the UK government. They verify the record of that operational creditor, and they further the verified record then comes forward in a shape of a notice and is served upon the debtor. And if the debtor does not, a 21 days time period is given under the UK law to a debtor to discharge his liability. If he does not come forward, then it becomes an undisputed statutory notice, on the basis of which the appropriate authority in that jurisdiction directly initiates the insolvency resolution proceedings. Now, we have discussed the with regards to the institutional infrastructure which this committee has proposed, and we have seen that how the categorization of the creditors this committee has proposed and which has also been materialized in the IBC. Now we just take a look at the what this committee has proposed for an individual person's insolvency. So this is a brief table. This is also available in the committee report. So this committee has proposed that whenever an individual is in distress, either he can be offered a fresh start, or his assets and liabilities can be restructured to provide him with a second opportunity to move forward with his business. So this is how briefly BLRC recommends the provisions for an individual in distress. So if an individual is eligible for a debt relief in a manner that he can pay off some of the debts to the creditors, then the BLRC recommends that he should be given a fresh start. And fresh start does not mean that his record of default will be erased. It only means that the claims of the banks will be extinguished, or in a better manner, satisfied to that extent, and the individual will be free to start its business from a new point. However, in the other case, if the individual is unable to pay off the debts, even to some extent, then the traditional, like the in the manner the company for the companies, the insolvency resolution process is recommended. Same process be followed for an individual, and if the insolvency resolution process is failed, then the bankruptcy process, which is the liquidation proceedings. So ultimately, the this committee report has recommended all possible manners that how the working of insolvency and bankruptcy code can be made swift, can be effective, how the speedy resolution can be there. And also one more part when we come to IBC. So in IBC, when we go under the liquidation proceedings, so there are provisions for assessing the fraud, malpractices, and other preferential transactions, which can be identified by the insolvency or resolution process professional, and can be put forth before the NCLT. So those provisions were also recommended by the BLRC report, that there should be incorporation of such provisions, and the insolvency resolution professional and the uh, insolvency resolution professional should be tasked with the duty to analyze the previous 2-year record of a debtor to find out if there have been any preferential transaction, avoidance transaction, or earlier terms it was antecedent transaction or any fraudulent transaction. So to give you an idea of a preferential transaction, that in the past 2 years, whether the particular there has been any transaction which is basically, for example, okay, let's say take an example that in a company, a promoter of the company buys a particular asset from the funds of the company, but in the name of some of his relative or any other related party to him. So that would be a fraudulent transaction, and such transactions ultimately hampers the overall financial position of a entity. So the insolvency professional and resolution professional is tasked with this duty to identify such transactions and to put them before the NCLT for appropriate action to be taken against such persons. And lastly, this committee has discussed that what all legislation should be repealed by coming into force the IBC, and what all legislation should survive can go hand in hand. For example, the SURFACE legislation is still in force. However, SICA has been repealed, and because SURFACE legislation and IBC has a very distinct procedures. SURFACE is more focused on debt recovery, whereas the IBC is more focused on resolving an entity out of the state of insolvency. So here the committee has recommended the the repeals and savings, and lastly, how to implement the recommendations given by the committee. So this committee has somewhat said in this part that though they have recommended and recorded findings for the implementation of a very good insolvency and bankruptcy code, this committee has also identified that still there is a lot of work which need to be done. For example, the recommendation of the committee with respect to IBBI, that particular board has to be constructed. The adjudication infrastructure in India has to be streamlined, has to be constructed in a manner, all the online filing systems, online video conferencing systems, and the start the insolvency profession, wherein the insolvency professionals would come into picture and they start playing their role as contemplated by the BLRC in the IBC. So in this part 8, the BLRC has laid down some points that how to implement this law in a better manner. And I know this session has been quite a long, but still I have tried to brief you about the what all points the BLRC has recommended. So, and also I would highly recommend to go through this report, read part 2 once, the executive summary part, because that part is consisting of almost all the important points which this committee has focused on. And uh, this committee report forms the very crux of the IBC. Why? Because if you see the Supreme Court judgments from the period of 2017 to 2019, for example, SR Steel case, SR Steel versus Satish Kumar Gupta, then there is Swiss Ribbons case, and all those initial landmark judgments, the Supreme Court has heavily relied upon this report to interpret the true intention of the IBC. So this report is very much necessary for understanding why IBC is important. And also, one more thing is there that this BLRC report did not only focused on the problems of the previous laws, but this committee report has given recommendations which are very futuristic and which is actually even after more than 8 years of IBC have not been implemented in true spirit. For example, when we discussed about the information utility, there is only one information utility in India up till now, which is the NESL having its registered office in Mumbai. Then, when we talk about the insolvency professional and establishment of insolvency professional agencies, there are only three insolvency professional agencies. One is by the ICAI, the Institute of Chartered Accountants of India. Then there is one insolvency professional agency by the Cost Accountants of India. And there is one insolvency professional agency by the ICSI, which is the Company Secretary Institute of India. So, however, this committee has foreseen and has also recommended that these uh, two regulated industries should be in open market so that the competition may increase. The and if the competition increase, obviously every entity would strive to work better, and the streamlining of the insolvency and bankruptcy framework would be more. So, I would request all of you to once go through this committee report so to understand the very basics of the insolvency and bankruptcy code. So that's it for today. Thank you so very much. I hope to see you in further sessions. Thank you.